Okay, the awarding of these, rather the floating of the tender and awarding of the same to individuals, it's, as much as it's a development thing, it is equally backed by the law and procedures that are stipulated within our laws, where public participation is not a suggestion, it's a must that Kenyans must be involved, stakeholders must be involved in this process. That there is already a matter in court that where Kenyans are demanding transparency. Kenyans are demanding we see the contract, and that while offering these new contract or awarding these to an individual, you still do that which a Kenyan is in court for. Why? I mean, from where you sit, is it by design that the requirements of the law are things that seemingly is not important for the government follow?
We've had a dialogue with the government and including the judiciary through various court cases on the importance of public participation. And in the past, the judiciary has struck down several actions of the executive and even of parliament on the basis of lack of public participation. And they have established several principles. Of course, as lawyers, we are a bit disappointed about 2 or 3 more recent decisions of the judiciary that seem to have lowered the standard again of public participation, which is a constitutional value. It's found in Article 10 of the Constitution and several other places. And of course, the media is a very important stakeholder in this issue, because when the information is availed, then you publish as the media, and Kenyans can see and interact with it. So when even the media is questioning, they are not aware of some of the details, you're just given half information, then Kenyans also are less informed. There is a problem. And our constitution is very clear in Article 31 and 35. Article 35 is the one that talks about access to information. And the government used to rely on Article 31, right to privacy. And the courts have said that right to privacy cannot be used to hide information that is necessary for Kenyans to exercise their fundamental rights and freedoms, and also for them to engage in good governance. So there is always a tendency of the executive to be a bit secretive, because this old idea of official secrets, official records, is very strong even within them. And unfortunately, it is in secrecy that corruption, misconduct tends to thrive.
And are we seeing that that could be a possibility here? And is that why there is a demand to say, make the documentation available so that we can actually see the process that this went through to arrive where we are?
You remember many years back when Safaricom was floated and privatized, and it was acquired by Vodafone. We remember we were told that now Safaricom has been privatized, it's going to work well, and indeed it worked well. And it took a few months, and then we had, there was a local company called Mobitelea, which had taken 10% of the shareholding. They had entered into a deal with the foreign company that had come in, and they had taken 10%. And we were wondering, who are the owners of this company? And we were being told that the owners of this company might be related to Moi and Biwott Telecom East Africa. So that was a way in which it seemed that a percentage of a public project was being acquired by public officials contrary to our laws on anti-corruption and so on. So it's what is called influence peddling. So we also want to be very careful and clear that there is no such arrangements that are in place, and that is why we need to see all the documents in this place. When you don't see the documents, the transaction documents, everything, those are the situations where you are likely to find deals that have been reached that increase the cost of project 10%, 20%. This, I'm not saying has happened. I'm saying these are the risks that can be resolved once you have full disclosure of the relevant documents. And there have been recent court cases that have said, under the Access to Information Act, the Fair Administrative Action Act, governments organs are meant to disclose contract documents to the public.
Okay, so that's my next question, actually, interestingly enough, was going to be that is there a requirement for full disclosure without the pursuit of the same by a party after the process?
Yes, actually, I was involved in a recent case. I've been acting for a party in a case involving the Rirutangong railway. And again, in that particular case, some of the residents of that area, Karen Langata Association, have been complaining that, you see, government has started a meter gauge railway project there, and they did not disclose documents to us. They are meant to do feasibility study, pre-feasibility study. They are meant to do serious public participation before they determine everything about the project. And all these documents under the law are meant to be disclosed. So we're able to persuade the court by showing them the relevant provisions of the Access to Information Act and the Fair Administrative Action Act that require disclosure by the government. And the court issued a court order saying that the project has to stop until the disclosure takes place. And now we are waiting for the final determination of that application. What I'm basically trying to say is that there is a legal requirement for disclosure. And if the disclosure is not done after you make a formal request, one can approach the court, and the court can even stop the project if the court is convinced that the disclosure has not been made. So we are asking the relevant agencies, do the disclosure. If they don't do the disclosure pursuant to the public request, you are going to do the formal demand for the full disclosure. And if they do not respond to that one, then we'll have no alternative